Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of proposed rulemakings under the Dodd-Frank Wall Street Reform and Consumer Protection Act. Today, we will be considering the end-user exception to mandatory clearing of swaps, business conduct standards with counterparties, and governance requirements for derivatives clearing organizations, designated contract markets, and swap execution facilities. I see they're already in the chair, Nancy and Ananda. In addition to those proposed rulemakings, the Commission will consider an interim final rule for reporting certain post-Dodd-Frank enactment swap transactions. The public might note that we had calendared for today discussions of swap execution facilities. I've also always said to the press, we're human. And so, as chair, I've decided this morning we're going to take that one up next week. I think we've had some good further discussions amongst Commission and the staff on that one. This probably is not going to be the last time that we recalendar something and need an extra week to get our work done. Before we hear from staff, I'd like to thank Commissioner Mike Dunn, Jill Summers, Bart Chilton, Scott Armalia for all of their thoughtful work. I say this every week. As we get into the holiday period, it is remarkable how much they are doing and their able legal assistants are doing to help us through all of this. I'd also like to welcome members of the public, market participants, and members of the media today, as well as to welcome those listening on the webcast. This is our 7th public meeting to consider Dodd-Frank rulemakings. We will have another meeting next week on the 16th, and we're planning 2 additional meetings on Dodd-Frank rulemakings in January, and we'll continue to announce our proposed rulemakings, which topics we're taking up 1 week in advance. And this is 1 week in advance, so I'm going to do this. I think we're also going to put it on our website. But next week, as I say, we're looking to take up this swap execution facility, as I just mentioned. We're also going to hear on, I think it's our 3rd round of clearinghouse rules. These will be the risk management rules on clearinghouses. We'll hear on our, what I'll call, 3rd round of internal business conduct. That round will be with regard to confirmations, portfolio compression, and portfolio reconciliation. Did I get that right, Ananda? And then also on position limits. And I wanted to make a few comments, if I might, be allowed on the position limits. What I've asked staff to do is to pull together 2 components. It might be in one vote, but I think it will probably be 2 rulemakings, actually, one on spot month and one on what we call all other months or all months combined. We've had a long tradition at this agency of setting position limits. We have spot month limits right now on pretty much, if I'm not mistaken, all of the physical commodities and some financial commodities. We've put out proposals this past January in the energy products. We think that we can move more expeditiously with regard to the spot month period. And it would be my hope that we could vote on something and then actually finalize something on the spot month area within the next few months. With regard to the all months combined and other months, as that is so data intensive, that too hopefully can be completed expeditiously, but there is the challenge of doing it and the data that's so necessary for it. And so I've asked staff to make a presentation and try to bring both rules up next week. I think that's what we're calendaring for next week as of right now. Commissioner Chilton, staff has been very involved and I think very forthright publicly about our need to move forward on position limits. I share that view. Congress did set different dates for us on that, 180 and 270 days rather than the 360 days. And so we're trying to work with that and we'll take more of that up. I'm sure other commissioners will have views on that and maybe share that even today at the end of our presentations. I want to thank staff for working on all the draft rulemakings. I thank them for their thoughtful recommendations. We look forward to receiving public comments on all that we're putting out today. There will be fact sheets and Q&As put on our website. Before I turn to the presenters, I turn to fellow commissioners. Commissioner Dunn.
Thank you, Mr. Chairman, and you'll recognize that we all are kind of talking funny. I don't know if that's because we've had so much discussion or if the chairman's sharing a cold with all of us, but it isn't indicative of the hard work that the staff has put in putting all this together, but more importantly, the commissioners working together to try to find some solutions to things.
We have been in close quarters.
He's been in my face a lot. I think that's the way. I want to thank you all for joining us today in this important meeting regarding the implementation of the Dodd-Frank Act. The business conduct standards for swap dealers and major swap participants is of particular interest to me, because I believe that strong standards for swap dealers and major swap participants are necessary to prevent another financial crisis. By implementing strong business conduct standards, the Commission can establish a meaningful protection for counterparties and hopefully prevent the types of behavior that necessitated the passage of Dodd-Frank. To me, Mr. Chairman, this is the heart of what we're supposed to be doing. An inherent conflict of interest exists when a swap dealer acts as both an advisor and a counterparty to its customers. The business conduct standard proposed today provide meaningful protection to the counterparties, and I support them, but I believe more can be done. I am particularly interested in public comments on this rulemaking, specifically whether the proposed rules go far enough in protecting counterparties. Dodd-Frank requires the Commission to consider whether to exempt small bank saving associations and farm credit institutions and credit unions from the definition of financial entities and its clearing requirements. I welcome public comment on whether any of these groups should be exempt, and if so, why. Specifically with regard to the Farm Credit Institution, I would like to know if the $10 billion cap on total assets meets the congressional intent. I'm concerned, Mr. Chairman, a decade ago, the Congress told the CFTC not to look at swaps and over-the-counter. In that period, that industry has developed, and it's quite different from the futures industry. I'm concerned that as we who know and understand the futures industry, and our staff has been working on that, fully appreciate that differences that has developed. And I hope that we're not trying to take what has worked well in the futures industry and say that has to be in the swap industry without taking into account how that swap industry has developed. So when we get to that point, I look forward to the comments from the public on what we're doing, if we are in fact going to achieve the purpose of Dodd-Frank in there, and are we going about it right. I've said before that I think it's important that we get these rules out in time because Congress has mandated it. But it's not an easy task. And what we get out, it's imperative that we get it right. So the public has got to give us comments in regards to these proposed rules so that we get that final rule right. But I think also inherent in that, Mr. Chairman and my colleagues, is a duty for us to follow up to ensure the efficacy of those regulations that we passed. And I've said this before, that I think in 12 or 18 months we need to review what we've done and what that impact has been. Again, I want to thank the staff for the great work that they've done on getting things together. And I get changes in the middle of the night from the staff, so I know somebody's up there working, and I appreciate it.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. And I, too, want to say thank you to all the rulemaking teams this morning for all the hard work and the rules that we have in front of us, or thought we were going to have in front of us this morning. A lot of these rules are complicated, and we really do appreciate all the time that all the teams put into making these rules be in a place for proposal stage where we feel comfortable getting the public comments. So thank you all for all your hard work. Last week, I expressed concerns about a number of the Commission's proposals that I felt were too broad or overreaching what I felt the statute directed us to do. This week, my concerns go the other way. Even though we're not considering the CEF proposal, one of my concerns this week is that we were defining CEF too narrowly. It's also a concern that I have regarding the end-user exemption proposal, because I believe the statute directed us to consider whether we should be exempting some of these small institutions. And although we ask questions with regard to that subject, we actually don't propose a framework for how we would go about exempting these small institutions. So in that area, I believe we have read the statute too narrowly. My opening statement today is almost solely with regard to the definition of CEF. So I will forego subjecting you to my concerns about the CEF definition until next week, but just say that I hope in the 7 days that we have to reconsider this rule that we will address some of the concerns about looking at that definition too narrowly. I will follow up by saying on the end-user exemption that I think that we need to consider whether or not the $10 billion limit is appropriate, and if there are other criteria that these institutions may have that would make them qualify for this exemption. I think that this is something that we really do need to look at. I would have preferred a framework be proposed in what we're doing today, but since we did not do that, I would suggest that the public and all of those who are concerned about this really do give us specific comment about how we could consider putting that kind of framework in a final rule. Again, thank you to the teams today. I look forward to hearing about these proposals.
Thank you, Commissioner Summers. I look forward to, because I think I know much of what's in your written statement, but we have 7 days, and it might actually change by next week.
Many of these things you have heard before.
Yeah, I'm sure. I'm sure. And on the end user side, I thank you. So for once, you want us to be more prescriptive.
Well,
No.
I suppose there's another way of looking
All
at
right,
that.
thanks.
Maybe follow what the statute says.
Commissioner Chilton.
I'd like to, if it's okay with the chair, defer to Commissioner O'Malley first and then go.
Absolutely. Commissioner Amalia.
Happy day. How often have I complained that I always have to go after Mr. Chilton? Now I get to go before him. Well, the holidays are upon us, and as many of you know, I have 3 daughters, which therefore means I have 3 wish lists. My youngest daughter, Macy, spent the weekend scouring the catalogs in search of the perfect gift to top her list. And you know what she came up with? A towel warming rack. She had no idea why she wanted it, but it was in the catalog, and thus had an equal opportunity as many of the other items to make the list. I didn't think much of the towel rack till I read the proposal relating to the swap execution facility, namely the part that aims to further define what a CEF is. And I thought to myself that this CEF rule is very similar to the towel rack episode. No reason, just because. I'm not buying a 7-year-old a towel warming rack, and I'm not supporting the proposed rulemaking on CEFs as it was drafted today. Unlike Commissioner Summers, I am going to expound a little bit on the CEF, even though we haven't. This is an important issue, and we had I think we're going to have a good, robust debate about it, and I'm just going to kind of share my views on where this thing is going.
Absolutely.
My views on it. So we obviously had a lot of time and options before interpreting the statutory language with the goal of providing greater pre-trade transparency. And the Commission chose a limited two-tier approach that relies on a narrow reading of the statute and a broad reading of an aspiration that, if adopted, will actually diminish the overarching goal of promoting the trading of swaps on CEFs. The rulemaking mandates that CEFs either take the form of a central limit order book for any project that trades for more than 10 times a day, or transparent request for quote or RFQ approach. The so-called transparent RFQ approach will require all bids and offers to be firm and provide a first-in-bid, first-in-fill approach. That's it. The staff has interpreted a minimal statutory requirement in the manner that entirely strips away the unique characteristics of swaps and that has been bandied about by the Commission for the past 20 years, and requires swaps to trade like futures, in my opinion. Looking over the history of the Commission's treatment of swaps, it remains abundantly clear that while swaps contain some features similar to those of futures, they remain sufficiently different that in their purpose, function, and design. To limit swap trading to a central limit order book exchange might be unnecessary to mitigate systemic risk, protect the public interest, and in fact may inappropriately burden commerce. That is, if swaps possess the same characteristics as futures, then Congress would not have needed to create a CEF definition to accommodate them. End users and buy-side participants are understandably wary about being forced into unfamiliar and inhospitable environments where high-frequency traders can undermine their ability to trade sizable positions, and nascent and illiquid markets threaten to divulge the positions through bidding alone. Like a seven-year-old wanting a towel warming rack, it just can't be right. But at least buying a towel rack helps commerce. I can't say that for this proposal. I want to be clear. I am in favor of increasing pre-trade transparency, as the chairman is so passionate for, and bringing more transparency and bringing more swaps to swap execution facilities and relying less on block trades. To achieve this, we must permit a broader range of venues to inspire market innovation, competition, and improve transparent market pricing. Congress's open-ended language is clearly intended to permit for flexibility across all trading venues. I ask that we interpret the statute broadly to permit the various RFQ and transparent voice broker systems already serving the industry to continue to operate with, at most, minor alterations. This, I believe, will allow market participants to ultimately determine what levels of pre-trade transparency and liquidity they require to manage risk. I checked back with Macy this morning about her list. She admitted it was a little long. She's being reasonable, and she is cutting out the towel rack. I hope we can get comments and input necessary to cut our list as well. Now, Mr. Chairman, I had shared with you an amendment that I thought was appropriate to broaden the definition of CEFs. I appreciate your willingness to pull the proposal and reconsider and possibly give this amendment some consideration. I've talked with my colleagues about it. I think it's a great opportunity to expand the definition, to give ourselves some optionality and what CEFs are going to be allowed, and I appreciate your willingness to work with me on it, and I hope that we can come to an acceptable solution. Because I think we all agree the goal of this objective is pre-trade transparency and flexibility for trading on the CEF environment. Now, from my experience working in the Senate, I do know how it feels to be in the hot seat, and I would like to thank Reva, although her rulemaking got pulled, and her teams for their efforts. They've worked long and hard. And I'd also like to thank the other teams headed by Phyllis Sella, Nancy Schnabel, and George Wilder and Susan Nathan. Appreciate their unwavering commitment to responding to my questions, comments, and criticisms with thoughtful consideration. Similar to my colleagues, I commend the end-user exemption team for drafting what overall is a very thoughtful and well-written proposal. However, I'm concerned as to why we are failing to fully fully address the issue of excluding small banks, farm credit institutions, and credit unions from the definition of financial entity. This is unreasonable. Section 2H, 7C, 2i directs the Commission, with their ever-important word shall, to consider whether to exempt these entities. And as pointed out by House Agriculture Committee Chairman Colin Peterson, quote, the regulators will have maximum flexibility when evaluating the risk portfolios of these institutions for consideration of an exemption, end quote. All we're going to do today, after almost 5 months with this language, is punt it. While I can appreciate the staff's decision to pose a series of questions aimed at further informing their consideration of the appropriate criteria for such an exemption, we are too far into these rulemakings to start from square one. As we move forward on the rulemaking, I encourage staff to keep in mind that many of the affected institutions play a critical role in our economic development of our small communities and rural areas. Excuse me. It is my hope that a final rule will ultimately permit the bulk of these institutions to avail themselves to an end-user exemption. As for the proposal for business conduct standards for swap dealers and major swap participants in their dealings with counterparties, and especially counterparties who are special entities, I believe the staff has demonstrated an extraordinary ability to effectuate the statutory mandates through consideration of congressional intent and in the manner in which market participants actually conduct their business. This proposal is especially timely as the Bank of America has just agreed to pay more than $137 million in restitution for federal and state agencies for their participation in a conspiracy to rig bids in the municipal bond derivatives market. However, the rule strives to ensure that counterparties dealing with sophisticated swap dealers and major swap participants are fully informed and, of course, have recourse if they are not. Prior to entering into these complex instruments, I support this proposal. I will say that I'm not entirely sold on the broader proposal to apply execution standards for all commission registrants transacting swaps available for trading on DCMs and CEFs. These standards are designed to ensure fair dealing and further protections against fraud and abusive practices, and these are good things. However, the proposal in part requires an execution ultimately to be on terms of a, quote, reasonable relationship to the, quote, best terms available for such a swap on a DCM or CEF. While this is better to require absolute best execution, the requirements of this proposal are somewhat vague and may ultimately become another rule in the book only relied on in the most egregious circumstances. I'm keeping my mind open, however, and look forward to reviewing the comments from a diverse population of commission registrants who may ultimately be affected by this proposal. In closing, I'd like to thank the dedicated staff who have worked night and day to preserve and make these changes in these rulemakings. And by all means, do not interpret my views to mean you should never request a towel warming rack. However, in making your wish list, please consider whether these items you choose are reasonable for the markets. Thank you.
Before I turn to Commissioner Chilton, I just want to mention that I know we're spending a lot of time together, and maybe there was an illusion that I was like your daughter Macy or something. But I'm going to take that as a glass is half full because I know you love your daughter Macy.
I love all three of my daughters.
Yeah. Well, if the chairman is in any way being alluded to of having a wish list, at least you're saying it in the context of your daughter Macy. So I'm feeling good about that.
You should. Thank you.
Thank you. We do work well together, even if we have a little bit different view on what the statute says about transparency and pre-trade transparency. But I'm going to save my thoughts on swap execution facilities until next week because I think that all of us are really working with this statute. And so it's a very detailed statute about swap execution facilities, what it means to be made available for trading. The proposal today, just because Commissioner O'Malley did mention it, when he mentioned these two tiers, there was a third tier in the proposal. Anything that's a block trade, anything that's an end user out of those commercial end users, anything that's not made available for trading would have been pretty much whatever the market wanted to use. Voice, limited request for quotes, things like that. So I was just augmenting what you were saying. But I look forward to working with everybody throughout the next 7 days on it. Commissioner Chilton.
Thank you, Mr. Chairman. For a couple of years, I've been supporting position limits. We had the authority to impose those prior to Dodd-Frank, but weren't able to get the support to do it. Now we have the law, and we just had these new speculative data that I talked about yesterday in New York, where we've seen more positions coming into markets than ever before, and there is certainly disagreement about the impact of speculators on prices, but any impact isn't acceptable. And we've just seen, gas prices raised 10 cents. Crude's around $90, raised $7 in 2 weeks. I read a quote in a local paper that said there's no reason that it's delinked from supply and demand. I'm not saying that it's speculators, but our job is to try and do what we can, and now we have the law on our side on position limits, and I'm pleased with that. And we have seen, all of us have seen, and this is public information, we've seen large concentrations. We've seen more than 20% in the crude market at times, more than 20% concentration by single trader in nat gas, roughly 40% by an individual silver trader. These are issues that, demand us to deal with. So I had a proposal that I was going to offer today, as my colleagues know, because I emailed them very late at night. But I really appreciate the chairman's commitment to taking this up next week and looking at this in a slightly different way, perhaps on the things that we can do expeditiously with regard to the spot months swaps, and then as soon as possible on the other months and on the aggregate months. It's an important proposal. I want to get it right. I appreciate that some of the concerns that my colleagues have, and quite frankly I have too, about making a fulsome decision on what the levels are. A bad rule is not good. We want to have a good rule. So I appreciate the chairman's commitment, and I look forward to next week. I did want to say just a brief thing on the CEFs. I was prepared to support the rule that we were considering. I did add some questions. I think Commissioner Dunn may have added some questions too. I want to make sure that we take into account both of the things that are in the law. One is promoting transparency, as the chairman has eloquently spoken about, and I support it. But, transparency isn't absolute. And the other test, and it's not a secondary test, it's not a lesser test, but the other test in the law is to promote CEFs. And so I want to make sure that our proposal does that. I think the proposal, as we had it, with the questions, allowed us any flexibility that based upon the comments that we could change it. But I look forward to taking it up next week, and I thank Reva and everybody else for their work on that and all the other rules today. Thanks very much again for your commitment, Mr. Chairman.
Thank you to all my commissioners and for their commitment to getting this very important project for the market done and done well and done right. With that, I'm going to hand it over to Ananda Radhakrishnan and Nancy Schnabel. Nancy, good to see you back here again, who's going to present an additional rule on governance with regard to, mostly it's with regard to reporting on governance. There is some fitness standards provisions as well. Nancy and Ananda.
Commissioners, Chairman, today staff is presenting the second rulemaking on governance and conflicts of interest, which I really hope is not like a towel warming rack. Before I just start discussing the rulemaking, I just wanted to thank you and the commissioners and their staff for very constructive comments. I would also like to thank my team members for working very hard on this rulemaking. So, back to the second rulemaking. The second rulemaking further implements the conflicts of interest core principles that each DCO, DCM, and CEF have. Additionally, the second rulemaking implements core principles with respect to governance fitness standards, as you said, and the composition of governing boards for DCOs and DCMs, and also diversity with respect to publicly listed DCMs. On October 1st, the Commission approved a proposal proposing certain structural governance requirements and certain limitations on ownership of voting equity and exercise of voting rights. These proposals were meant to implement Section 726 of the Dodd-Frank Act, which require the Commission to promulgate certain rules to mitigate conflicts of interest. Staff believes that the notice of proposed rulemaking today will complement any final rule that the Commission contemplates adopting with respect to Section 726 of the Dodd-Frank Act. First, with respect to the conflicts of interest core principles, basically, these core principles require a DCO, DCM, or CEF to establish and enforce rules to minimize conflicts of interest and to establish a process for resolving conflicts of interest. To further implement such core principles, staff is proposing requirements on reporting, maintenance of a regulatory program, transparency, and limitations on use of non-public information. With respect to reporting, staff is proposing to mandate that each DCO file a report with the Commission whenever its Board of Directors rejects a recommendation or supersedes an action of its Risk Management Committee, or whenever its Risk Management Committee rejects a recommendation or supersedes an action of its Risk Management Subcommittee. And also, staff is recommending that each DCM or SEF file a report with the Commission whenever its Board of Directors rejects a recommendation or supersedes an action of its Regulatory Oversight Committee or its Membership or Participation Committee. Further, under reporting, staff is proposing that each DCM, DCO, or SEF provide certain reporting on the composition of its Board of Directors within 30 days after the election of its Board of Directors. And also, staff is proposing to require that the Regulatory Oversight Committee of each DCM or SEF to prepare an annual report assessing the various components of the DCM or SEF regulatory program, and such a requirement generally parallels current acceptable practices under DCM Core Principle 15. So moving on to the regulatory program, staff is proposing to require that as part of its regulatory program, each DCO, DCM, or SEF establish, maintain, and enforce written procedures to identify on an ongoing basis existing and potential conflicts of interest, and to make fair and non-biased decisions in the event of such a conflict of interest. With respect to transparency, staff is proposing to establish minimum standards for transparency of the governance arrangements of relevant DCOs, DCMs, and SEFs. And transparency would be transparent to the public as well as to the Commission. And the minimum standards require each DCO, DCM, or SEF to make available certain information to the public and relevant authorities with respect to governance, such as charters, nominations process descriptions, identities of public directors, etc., and also ensure that the information that they make available is current, accurate, clear, and readily accessible. And finally, to disclose summaries of significant decisions. Significant decisions involve those areas in which conflicts of interest may be most manifest. With respect to a DCM or a SEF, significant decisions will relate to access, membership, and disciplinary procedures. With respect to a DCO, significant decisions will relate to open access, membership, and the finding of products acceptable or not acceptable for clearing. And staff wants to make very clear that they do not recommend and they do not require that DCOs, DCMs, or SEF make public any non-public information as that is defined within this rulemaking. We move to limitations on use of non-public information. And so each DCO, DCM, or SEF, staff is recommending to establish and maintain written policies and procedures on safeguarding non-public information. These procedures and policies must, at a minimum, preclude each registered entity's members, directors, certain officers, and certain affiliates, and also members of the disciplinary committee and disciplinary panel, if they are not also members of the board of directors, to not disclose any non-public information absent prior written consent. And finally, staff believes that these written policies and procedures are important because they would prohibit those in a position of power at a DCO, DCM, or SEF from leveraging such power to benefit themselves or to the detriment of their competitors. So, second, in addition to implementing the conflicts of interest core principles, the rulemaking today implements certain core principles with respect to DCO or DCM governance fitness standards and composition of the board of directors or other governing bodies, and the DCM core principle on diversity of certain boards of directors. With respect to governance fitness standards, staff is proposing to require each DCO or DCM to specify and enforce fitness standards for its members, directors, members of any disciplinary panel or disciplinary committee, persons with direct access, and certain affiliates. And these proposals generally codify the acceptable practices under current DCM core principle 14, and extend such practices to DCOs. And with respect to composition of the board of directors or other governing bodies, staff is proposing to require each DCM to design and institute a process for considering the range of opinions that market participants hold with respect to functioning of an existing market, as well as new rules or rule amendments. And for DCOs, staff is proposing two alternatives that the Commission will adopt in its entirety rather than an alternative that a DCO can choose in and of itself. And the first alternative is that the DCO would be deemed in compliance with the core principle on composition of the board of directors or other governing bodies if it has 10% customer representation on its risk management committee, which is what staff had recommended in October 1st, 2010. And the second alternative is they would be deemed in compliance if they had 10% customer representation on their board of directors. And we're seeking public comment on this proposal because this proposal would basically keep the question open with respect to customer representation until after the 180-day implementation period for the first rulemaking.
Is there a motion on the staff recommendation?
Move to adopt the recommendation.
Second.
I support the proposed rulemaking. I will have one question on the last thing that you said, but I think it builds upon a proposal that's out there, and we're looking to try to finalize in that 180-day period of time. And importantly, it builds on the reporting to the regulators and a little bit of reporting to the public related to the fitness standards. But I just had a question on the last point you just went through, Nancy, about you said would keep the comment period past the 180-day. I didn't. Could you walk through that again?
Sure. I mean, we're definitely going to adopt rules to implement Section 726, or I guess we hope to adopt rules. We would recommend
Staff would be recommending.
Exactly. That's what I meant. So basically, those rules will have certain board composition, or staff will recommend perhaps that those rules will address board composition or governing other governing body compositions. But with respect to customer representation, because we have received opposing comments, we're basically seeking more public input on this one specific issue, and we intend to implement customer representation requirements if you all agree. Basically, with respect with the final rulemaking on the second rulemaking, so the final second governance rulemaking.
So you're saying, public, please keep telling us about the customer representation piece, and
Yes,
that piece
please.
is in essence being a little bit sort of cabined off a little bit.
That's right.
Okay, I think I now understand it. Commissioner Dunn.
I'm in agreement with this proposed regulation. I think staff has done a very good job on it, but I want to follow up, and I know there is news out about appropriations and what we might be getting in that area, and I thank you, Mr. Chairman, for going to the Hill yesterday, or was it the day before that you...
I seem to be there many days. I can't remember all of them, but I do thank the House of Representatives and what they've done. But we're not there yet, Commissioner Dunn.
But it does bring me down to the fact that what we're asking is DCOs to write a report on what they're doing on conflict of interest concerns, and I would like to know how the division is going to review that and what type of actions are going to be taken when we get these types of decisions.
Well, I would, if all goes well and the Commission does get the appropriation that it seeks, and if the hiring process goes as smoothly as we hope it does, then we would be in a position to hire sufficient staff to look at these reports. And if we find that there are certain things wanting, we'll of course go back to the DCOs to find out why it is they weren't able to comply fully with the aspects of the law. So I guess the answer is, if we do get the staff that we had asked for, then we'd be in a much better position to review these reports.
Do you have a timeline in mind in which the division would review these reports as they come in?
Well, the report is supposed to be annual?
This one is whenever there is a conflict.
Oh, whenever there's a conflict. I guess it depends on... I can't predict when we'll get these reports because it's event-specific, if I'm not mistaken. So if you're asking how long it is we will take, depends on the length of the report. And hopefully we can, review reports, I'd say within a week. But again, it depends on, what it is we get.
It's too late, you said 1 week.
Beg pardon?
I said it's too late, you said 1 week. I just think it's very frustrating for somebody that says that they think there's been an injustice, and they go through the internal process, and then they look at us as the court of last review on this. And I think we owe it to them to try to get out and say, all right, we're going to respond in such and such a time. And I think 2 weeks, a week, you're shooting from the hip. But I do want to make sure that we have a mechanism set up within the division to review those in a prompt and in a timely manner.
Oh, sure. I mean, you're right. I'm shooting from the hip because I don't know what I'm going to get. So that's the issue.
You're estimating.
I am estimating. I'm always conservative because I don't like to overpromise things to the Commission.
Commissioner Summers?
Thank you, Mr. Chairman. Nancy, I have a couple of questions with regard to our coordination with other regulators, not just domestically but internationally. And in the preamble, you talk about certain elements that we have included from both the European Commission proposal and CPSS IOSCO. If you could walk us through that.
Sure. Basically, with respect to the European Commission proposal, I mean, we took various elements. One element would be actually the reporting requirement that we just discussed, which is whenever there is an overrule by the board of the Risk Management Committee, then the CCP, which is a terminology that they use for DCOs under the European Commission proposal, would have to file a report. So that's definitely one place. With respect to CPSS IOSCO, there were various, because those principles are, there are two different CPSS IOSCO principles. There are the ones that are currently in effect, and then there are the ones that will hopefully become in effect next year. The ones that are currently in effect, basically with respect to governance arrangements, not require, I would say, suggest or recommend greater transparency and also clear organizational structure. And so we took some of those proposals from CPSS IOSCO with respect to transparency to both the public and to the Commission, and with respect to, I guess that's it, actually.
I just want to clarify, because I think I heard this when we were talking with the European Commission with regard to their proposals on this, that conflicts of interest may be one area where we are not fully on the same page.
That's correct.
Okay. And what about the SEC? Have they already proposed their entire conflicts of interest rules?
They've proposed most of their conflicts of interest rules. I think that they have some requirements that may be coming up in their entity, basically, rulemaking, such as the SAF rulemaking or their swap-based SAF rulemaking. So they're nearly done, but not completely done.
And are we consistent with what the SEC is doing?
We are mainly consistent. I mean, there will be differences here and there, but we are consistent.
Can you highlight any of the differences that you think are meaningful?
Well, I mean, I don't necessarily want to speak on behalf of the SEC, and I'm not sure what part of our discussion is necessarily public. I mean, for instance, this rulemaking, some of the provisions here, the SEC do not have similar core principles. So whether or not they're going to implement some of the provisions in this rulemaking in its entirety is unclear. But I really can't speak for them. So I think that those might be the areas where there would be some discrepancy.
Thank you.
Thank you, Commissioner Summers. Commissioner
I don't have any questions.
Chilton.
Thank you, Mr. Chairman.
Oh, there you go. Commissioner Malia, you're not going after him again.
Beautiful day. Nancy, I just have one question. The proposal requires summaries of significant decisions implicating the public interest, things like membership access and discipline, which would include a rationale for the decisions, and the process for reaching these decisions would be made available to the public. How are we going to protect appropriate business confidential or other items that should be held privately?
Actually, I thought I took those two provisions out of the proposal because of questions that were raised with respect to protection of non-public information. But if somehow they were not taken out, I will now take them out. But actually, we've inserted a provision that states that the requirement does not extend to non-public information that a DCO, DCM, or CEF basically has.
Can I just help out there by ask by unanimous consent if they're not out yet that they be taken out? Any objections? No, sir. Not hearing any objections by UC, just to make sure you have the authority to take them out in case you hadn't.
Thank you, Mr. Chairman, and thank you, Nancy, for your sensitivity to these issues.
Not hearing any further questions, want to call the roll on the staff recommendation as possibly amended by that UC, but you may have already done that. Dave Stawick.
Commissioner O'Malley.
Aye.
Commissioner O'Malley, aye. Commissioner Chilton.
Aye.
Commissioner Chilton, aye. Commissioner Summers.
Aye.
Commissioner Summers, aye. Commissioner Dunn.
Aye.
Commissioner Dunn, aye. Mr. Chairman.
Aye.
Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you. Thank you again, Nancy and Ananda, for your excellent work. We'll see you back, I guess, in January when you're proposing something on the first final rule. And so now we're moving on to the end user proposed rule. George Wilder from the Office of General Counsel. I don't know if somebody's coming up to the desk with you. Dan Berkovitz as well, maybe? We'll present rules related to end-user exemption for mandatory clearing of swaps. As they were getting situated, Congress said that non-financial end users hedging or mitigating commercial risk would have a choice. They get to decide whether to use a clearinghouse. And what we're hearing from staff on today is that proposal, as well as Congress says we shall consider exemptions for smaller financial institutions, those less than $10 billion, farm credit institutions, credit unions, insured depository institutions, and this list of questions to help us do that. George and Dan.
Let me begin by thanking each of you and your staffs, each of my teammates, and each of our SEC staff colleagues. Everybody has been very helpful, and I am very grateful. I will address 3 topics: credit risk, commercial risk, and financial entities. These 3 topics are key to understanding our proposal. First is credit risk. As you know, credit risk is handled differently for cleared and non-cleared swaps. So for non-cleared swaps, 10 disclosures about meeting credit risk will be required. These are not burdensome disclosures under our proposal. We propose an easy-to-use system that uses a check-the-box approach that covers 10 items or boxes to check. These boxes ask whether a written credit support agreement is involved, whether pledged or segregated assets are involved, whether written third-party guarantee is involved, whether the end user will rely on its own resources, and whether other means of meeting credit risk are involved. There are also 4 identity questions: identity of the electing counterparty under the rule, whether a financial entity is involved, whether a captive finance affiliate is involved, and whether an SEC filer is involved. And if so, whether the board approval requirement has been met. There is also a 10th question, whether the swap is being used to hedge or mitigate commercial risk. And this leads me to my second topic. Not all swaps are eligible for the end user exception. Only swaps used to hedge or mitigate commercial risk qualify. So how does an end user know whether its swaps qualify? We provide guidance in our proposal. There are 3 ways to qualify. If the swap is eligible for hedge accounting treatment, it qualifies. If the swap is eligible for a hedge exemption from position limits, it qualifies. And if the swap reduces risk relating to the end user's assets, liabilities, or services, it qualifies. In our proposal, we also provide guidance about which swaps do not qualify. Swaps used for speculation, investing, or trading do not qualify for this exception. Nor do swaps used to hedge another swap unless that first swap itself is used as a hedge. This leads me to my third and final topic, financial entities. As a general rule, financial entities cannot use the end user exception. But the Dodd-Frank Act permits the CFTC to consider whether to allow small financial institutions to use the end user exception. Accordingly, we propose that the Commission invite comment on its options here and how it should proceed. Before closing, there is one more topic that I'd like to discuss. Our system, what we propose here, our system uses reporting to SDRs as the end user's way to comply with the Dodd-Frank Act's requirement for notice regarding non-cleared swaps. So the Commission's oversight and enforcement effort for end users will depend upon this SDR database. Thank you. That's all I have.
Thank you, George. Do I hear a motion on the staff recommendation?
So moved.
I support this proposed rulemaking on end-user exception. Congress decided that non-financial entities mitigating or hedging commercial risk will have a choice whether to submit their transactions to a clearinghouse. If they want to, they can. If they don't want to,
That's right.
They're out. And the reason I support the rule is, in essence, this proposal says that if a company, a non-financial company, is using a swap to hedge an asset, a liability, an input, a service that it currently has or uses, or even if it just anticipates having the asset, the liability, the input, or the service, and it's hedging that, it would qualify for the end-user exception. It also says very specifically this could be a currency risk,
Yes,
an interest rate risk, a physical commodity risk, and so forth. In addition, just if that wasn't clear enough, it does say that if the swap meets generally accepted accounting principles as a hedge or is used as a bona fide hedging, which is under the Commodities and Exchange Act, another concept of hedging, the transaction would qualify for the end-user exception. But it's not reliant on a generally accepted accounting principle or a bona fide hedger. It's much more expansive, again, hedging an asset, liability, input, or service current or anticipated. And thus, I think that it complies with what congressional intent it was in terms of the non-financial entities. George also went through, as he said, 10 questions on credit risk. We're only doing that because Congress mandated there had to be a notification.
That's right.
and many people don't focus on that, but so we've tried to make that a check-the-box approach, make it very straightforward for end users, and that those could be just sent off to the swap data repository, as I understand it. So I think these are very good. We do have in this proposal also something with regard to financial entities, because Congress said we shall consider for those insured depository institutions, farm credit institutions, and credit unions that are less than $10 billion, exceptions from the generalized rule that financials come in. And I know that some of my fellow commissioners had hoped that we would be very explicit and have a proposal on that today. And if anybody's at fault, it's probably me. With today, I think we'll be up to 36 rules. I suggested some time ago a little bit more process to ask the public for some help on this very important thing. I think Congress was specific. They said we shall consider it, and we have a series of questions to help us do that. But it would be my full anticipation that sometime over the next, I guess we have about 7 months to go here, that we would be learning from the public and taking that up as well. But with that, I really don't have any questions.
Thank you.
Commissioner Dunn.
Thank you, Mr. Chairman. And this has been probably one issue in the Dodd-Frank that we've heard more about, folks lining up to be exempted as an end user. We've had a lot of them in our offices. We've received a lot of information from them, but now it really counts. So those folks who are concerned about the end user exemption, now is the time to get our comments in. What happens in the next 30 days on this is extremely important. And I'd like to recognize George for the important work that he did on the Hill in getting this legislation out. And I'm going to quote from the Congressional Record of June 30th of 2010, House 5246 page, and it's Mr. Holden from Pennsylvania asked to engage with a colloquy with Chairman Peterson from the Agricultural Committee, and if you'll indulge me, Mr. Chairman, I'd just like to read that colloquy and what led up to it. Mr. Holden says, over 20 years ago, the Agricultural Committee put in place a revised legislation and regulatory regime for the farm credit system that has successfully stood the test of time in ensuring that these institutions operate safe and sound. I'm very proud of that because I worked for Chairman Leahy on that particular legislation. Bob Cashdollar on my staff was my counterparty for Mr. Jones over on the House side, and it did work well. I'm glad Mr. Holden recognized that. The farm credit institutions are regulated and examined by a fully empowered independent regulatory agency, the Farm Credit Administration, which has the authority to shut down and liquidate a system institution that is not financially viable. In addition, the Farm Credit System is the only GSE that has a self-funded insurance program in place that was established to not only protect investors in farm credit debt securities against loss of their principals and interests, but also to protect taxpayers. These are just a few of the reasons why the Agricultural Committee insisted that the institution of the Farm Credit System not be subject to a number of provisions of this legislation. They were not the cause of the problem, did not utilize TARP funds, and did not engage in abusive subprime lending. We have believed that this legislation should not do anything to disrupt this record of success. Mr. Speaker, I would now like to enter into a colloquy with the Chairman of the Agriculture Committee. The conference report includes compromise language that requires the Commodity Futures Trading Commission to consider exempting small banks, farm credit systems, and credit unions from provisions requiring that all swaps be cleared. We understand that community banks, farm credit institutions, and credit unions did not cause the financial crisis that precipitated this legislation. While the legislation places a special emphasis on institutions with less than $10 billion in assets, My reading of the language is that they should not in any way be viewed by the Commodity Futures Trading Commission as a limit on the size of the institution that should be considered for an exemption. Mr. Chairman, would you concur with that? Mr. Peterson, yes, I fully agree. The language says that institutions to be considered for exemption shall be include those with $10 billion or less in assets. It is not a firm standard. Some firms with larger assets could qualify, while some with smaller assets may not. The regulators will have maximum flexibility when looking at the risk portfolio of these institutions for consideration of an exemption. We all know that legislative history and colloquies are not part of the statute per se, but we're driven by that because that's the intent of the Congress, and that's what we ought to be looking at here. As I read that, that tells me that Congress thought for small banks, for credit unions, and for farm credit institutions, that $10 billion is not an absolute threshold. And it confers upon us as the regulators when making those decisions to talk to the NCUA for credit unions, to talk to the Farm Credit Administration for the farm credit systems, to find out exactly what is at stake and what risk these institutions has as we make these considerations. I would like to ask if that's the intent of what we have in this regulation and how we're going to be doing that.
Well, thank you, Commissioner. Yes, it is. We have been in contact with Farm Credit Administration. We've been in contact with the NCUA and other regulators around town. So you're absolutely right. That's what Congress had in mind. And we're hoping to hear what the industry has to say and help us through this, because there are some issues, as you know, among the different categories of financial institution that are going to be challenging. So that's why we've taken a cautious approach here, and we're looking forward to hearing more.
Thank you, Commissioner Dunn. No, I fully hope and even expect that we will hear from the public, and I think it will help inform this commission. So, yes, it may be a cautious view, but I think it would be very helpful to hear from the public on those set of questions. Commissioner Summers.
Thank you, Mr. Chairman. I just want to follow up with some specific questions on this same area and just clarify that in the statute, although there is this $10 billion or less, the statute says including institutions that are $10 billion or less.
You bet.
In the colloquy, Mr. Holden points out that he thought that gave us the flexibility to include institutions that were above $10 billion.
Yep.
So where do you believe or what criteria should be in a risk profile that we look at to decide whether or not an institution that has more than $10 billion or that would qualify, an institution that has less would not?
There's probably going to have to be some consideration of a credit risk, a risk to capital, a percentage of capital, perhaps, that is related to the exposure that the institution has to swaps. Some of these institutions are large asset-wise, but they're really not that big in terms of their swap activities. So it means that the asset test may not be the best way to go. So we also have to be somewhat concerned, I think, about having some measure of parity amongst the four asset or categories of institutions that are covered by this rule. Congress did say it not once, not twice, but 3 times that they were suggesting the asset-based test for each category. So there may be a message there. But you're right on target that Congress recognized this problem, and they've directed us to solve it. And there are solutions there. We just need to be able to build a record to support what we do.
What do you think are the challenges in us figuring out what the solutions are?
I think that we need to recognize that the four categories compete with each other, so that, particularly, say, for ag lending, so that we need to be careful about not being perceived as tipping a balance for those markets. We need to take into consideration antitrust concerns here under the Commodity Exchange Act. That's not an insurmountable problem. I think that actually that there's probably a good solution to this, but it's going to require us to build a record, an administrative record, that will support what we do.
Because all we do in this proposal is ask questions and we don't actually set up a proposed framework for how we would have a solution to this, does that preclude us from being able to include a framework for exemptions in a final rule? Because this seems to be more like an ANPR to me on this particular issue. So then are we going to have to go out with another proposal with regard to this?
That's a good observation. And you're right. There's a problem if the Commission feels that it wants to go to a final rule. It won't be able to do that at this point. But there are options. The Commission has options here. And there's a possibility of issuing an order. There's several ways the Commission could issue an order here. The Commission may very well issue an order without taking further comments in the Federal Register. That's a possibility. So it's not like we're foreclosing. You're not foreclosing yourself by just asking for comments at this point. There's flexibility.
Okay. I guess I would say that I think this is a good rule. I think you've done a great job. Except for these provisions. And I fear that by delaying getting comment on a particular solution for this, delaying going final with a process for exemption may have a lot of unintended consequences and may actually go against congressional intent. Thanks, George.
Thank you.
Commissioner Chilton.
I just have a quick comment. George, I think you and your team have done a really good job, and I thank you. I've talked a little bit about this before generically when I've said, a lot of people that have come in have met with us want the line for regulation to begin right after them. In this case, the line, they want to be included. It's long, and in some cases it's sort of laughable who's requested this. And I don't want to make light of it saying it's laughable, but, we've had hedge funds in here that have said they're end users. I even had somebody suggest that an ETF, since they are the natural counterparty to some of the end users, needed to be included in this. So some of these requests, while you want to take them seriously, quite frankly, don't pass the smirk test. I think that you've done a really good job here at striking a reasonable balance. I'm not suggesting that it can't be improved, that we won't get some additional comments will be helpful, but I thank you and your team for your good work.
Thank you.
Thank you, Commissioner Chilton. Commissioner Amalia.
George, let me add to the course. Great rule.
Thank you.
Except for one item.
Yeah, one little thing.
Yeah, and unfortunately, with regard to the farm credit system, I think we've missed it by a country mile.
Right.
I think every commissioner has mentioned it, and this issue is the $10 billion. I mean, Commissioner Dunn obviously raised it, and Commissioner Summers as well. And last night at 7 o'clock, which, while maybe late for dinner, when you sent around a new question on this issue,
yeah.
It really isn't late in terms of rulemaking. This is early for a 7 o'clock change. But I think in the question, though, you left out three important words. And it says, in Section 2H7(2)(i), Congress directed the Commission to consider exempting depository institutions, farm credit institutions, and credit unions with total assets less than $10 billion. But when you go to the Act, it says, including such entities with them. Well, that makes a big difference, obviously, in who we're considering in this question, or who should respond in the nature of the question. Can we put in including such entities back into the question so it's more consistent with the statute?
Well, we are asking this question whether there are measures other than $10 billion in assets. So we're not only asking here in terms of perhaps going above $10 billion, but we're also asking, are there different tests that we could use? So I think this question is consistent with what Congress intended.
Well, why don't we put their words back in our question?
Be happy to
Does
do
anybody-
that.
do we have an-
What are the words?
Including such entities, straight from the statute.
Including such entities.
Yeah.
Did we get closer to your country mile then,
It's
Commissioner
just the
O'Malley?
word
Yeah,
including.
we're within a country mile then.
Oh, including, what's the word?
Including such entities.
I'm asking unanimous consent to include those three words. Was it three words?
Yep.
In the question that came around at 7 o'clock last night.
Yeah.
Not hearing any objections, we've included those three words.
Thank you. Obviously, my colleagues have covered the ground on this one, and I appreciate great rulemaking, and I look forward. Do you think I'm not proposing it, but do you think maybe a staff roundtable on this issue, since we're starting from scratch, would be a good idea?
You're asking me.
I was just kind of putting it out there.
Sure. That's a possibility.
It's maybe I'm going to be just at the end of the day, there's going to be rules that come out and on this small bank, small farm credit, small credit union provision. I don't think we necessarily delay. I think actually we are building a constructive administrative record. I think as a commission we owe that to the rulemaking process. And as Commissioner Chilton has said, it is a long list of people that have come in and said, we're really not what Congress intended when they wrote that. And then you can fill in swap execution facility, swap dealer, major swap participant, almost anything in there. And you can look on our website because we publicly post the 500 meetings, but it's a good assumption that a large percentage of those are coming in to say we're not what Congress said. So this area where Congress actually said we shall consider exempting these financial institutions from an otherwise financial institution definition, and I will own up, and I am proud of this decision, is to build an administrative record. This may be a bit more cautious than as Commissioner Summers would want, but I think it is something that's incumbent upon this commission to do well and do something that's sustainable in the courts after we do it.
Mr. Chairman, if I could just add a clarification so that the intent, the language in the proposal was a slight paraphrasing of the statutory language. But if you put in institutions, including, we also had taken out the description of the banks as small banks and small institutions. So we may want to parallel the exact phrasing in the statute.
Is that all right with you, Commissioner? Yeah. So we'll consider that a technical cleanup.
Correct.
Thanks. If there are no further questions, then Dave Staywick, could call the roll.
Commissioner O'Malley?
No.
Commissioner O'Malley, no. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 3, the nays are 2.
Thank you, George. Thank you, Dan. We'll see you back. And now we're moving to a notice of proposed rulemaking, staff's presentation on business conduct standards for counterparties, or what we've sometimes called on our website and elsewhere external business conduct standards, which are very important to protect the public. I think that Congress, I'm filling a little time here for the public as people are coming in, but the Congress clearly gave the SEC and the CFTC authority to set business conduct standards to protect against fraud, manipulation, and other potential abuses, promote market integrity, and importantly, promote a system of sales practices to protect counterparties. And we're going to hear from Phyllis Sella, who's the team lead and is also our deputy director of the Division of Enforcement, Vince McGonigal, who is our acting head of enforcement, Peter Sanchez, who's ever present on the team, and then Ananda Radhakrishnan, who heads up our Division of Clearing and Intermediary Oversight, is also back for yet another cameo. Phyllis.
Thank you very much. Good morning, Mr. Chairman, Commissioners. Before presenting an overview of the proposed rules, I really would like to thank the Commission and its staff for your support and guidance during the rulemaking process, and in particular, Tim Karpoff for his wise counsel. Don't see him, but I also would like to thank my team.
Here's Tim. You want to tell him in person again?
Yeah, your wise counsel, you missed it. I want to thank my team, Pete Sanchez, Katie Driscoll, Ted Neller, Barry McCarty, Michael Solinsky, Russ Battaglia, Vivek Jain, John Dolan, Todd Prono, Stephanie Horn. We have worked closely with our counterparts at the SEC, and I would like to acknowledge Lourdes Gonzalez, the team leader there, and her team. In the course of preparing the proposed rules, we received very helpful advice from numerous stakeholders through letters and consultations, and also from staff at fellow regulators at the OCC, Fed, Department of Labor, the European Commission, and the UK FSA. This has been truly a collaborative effort which has resulted in the recommendations that we are making today. Section 731 of the Dodd-Frank Act adds Section 4SH to the Commodity Exchange Act and requires the Commission to promulgate rules to establish business conduct standards for swap dealers and major swap participants dealing with counterparties generally. In addition, Dodd-Frank empowers the Commission to promulgate rules to implement specific protections for special entities, like state and municipal governments. The proposed rules will principally apply to swap dealers and major swap participants when they know their counterparty before entering into a swap. Often, these will be uncleared bilateral swaps. The disclosure and due diligence requirements will not apply to swaps initiated on a designated contract market or swap execution facility where the swap dealer or major swap participant does not know the identity of the counterparty prior to execution. In addition, where both counterparties are swap dealers, major swap participants, security-based swap dealers, or major security-based swap participants, the disclosure and due diligence obligations will not apply. Generally speaking, there are three groups of proposed rules: the general provisions, the duties that relate to dealings with all types of counterparties, and conduct rules that apply to dealings with special entities. The general provisions include requirements to have policies and procedures, diligent supervision, and record retention related to the business conduct standards. They also address acceptable means of complying with the new requirements. The general provisions contain prohibitions against fraud, manipulation, and abusive practices. The anti-fraud provision incorporates the statutory text from new Section 4SH4, which applies to swap dealers and major swap participants and prohibits fraudulent, deceptive, and manipulative practices. These proposed rules also prohibit disclosure of material, confidential, counterparty information, and trading ahead and front-running of counterparty swap transactions. Coupled with the proposed internal business conduct rules requiring codes of ethics and information barriers, these rules are intended to protect counterparties from abuse by swap dealers and major swap participants, including undermining the interests of counterparties by misappropriating their trading opportunities. The second group contains disclosure and due diligence requirements for dealings with counterparties generally. It begins with a duty to verify that the counterparty is an eligible contract participant and to determine whether a counterparty is a special entity. It continues with a duty to disclose the material risks and characteristics of the swap and the material incentives and conflicts of interest of the swap dealer or major swap participant in connection with the swap. As part of the duty to disclose material risks, SDs and MSPs would be required to provide a scenario analysis for all high-risk, complex bilateral swaps. For bilateral swaps that are not available for trading on a swap execution facility or a designated contract market, counterparties would be able to opt in to require a scenario analysis from the SD or MSP. For uncleared swaps, there is a duty to disclose the daily mark, which is defined as the mid-market value of the swap, and a duty to notify a counterparty of the right to clear, that is a swap that is exempt from mandatory clearing, and to select the DCO. Under the proposed rules, SDs and MSPs would also have a duty of fair dealing and good faith and would be required to communicate in a fair and balanced manner. In this regard, there is also an institutional suitability obligation when swap dealers or major swap participants make recommendations to counterparties. The third group of rules applies to dealings with special entities. The statute requires that swap dealers that act as advisors to special entities must act in the best interests of the special entity and make reasonable efforts to obtain information necessary to ensure that their recommendations are in the special entity's best interests. The proposed rules adopt the statutory text and clarify that acts as an advisor to a special entity includes recommending a swap. The legislative history of Sections 4S, H4, and 5 indicates that swap dealers should be able to continue to recommend a swap to a special entity and then enter into the same swap as a counterparty. For the statute and proposed rule to operate this way, the best interest duty would have to be interpreted to allow principal transactions between an advisor and its counterparty. Looking to case law, the best interest standard would require the advisor to put the client's interests first by acting in good faith and making full and fair disclosure of all material facts and conflicts of interest, and employing reasonable care that any recommendation is designed to further the purposes of the special entity. It would not bar principal transactions per se where the conflicts are properly disclosed and the counterparty consents. When acting as a counterparty to a special entity, swap dealers and major swap participants will have a duty to ensure that the special entity has a representative, either in-house or external, who is independent of the swap dealer or major swap participant and who satisfies certain other criteria, including that the representative acts in the best interests of the special entity. When dealing with ERISA plans, there will be an additional duty to verify that the plan has a representative that is an ERISA fiduciary, and when dealing with a municipal entity, there will be an additional duty to verify that the municipality has a representative that is subject to restrictions on certain political contributions or paid-to-play restrictions. Swap dealers and major swap participants also would be subject to pay-to-play restrictions when dealing with municipal entities. This rule is similar to existing rules for investment advisors and municipal securities dealers. Finally, the proposed rules would require registered commission intermediaries that handle customer orders for swaps that are available for trading on a swap execution facility or designated contract market to execute such orders on terms that are reasonably related to the best terms available. Thank you, and I look forward to your comments and questions.
The chair will entertain a motion on the staff recommendation on external business conduct standards.
So moved.
Second.
Thank you so much, Phyllis, and everybody on the team. I know this is a lot of work that's gone in over the last number of months and a lot of consultation, and I'm glad that you listed it. We shared, as I understand it, drafts of this as it was coming through with the SEC and the federal banking regulators. Is that correct?
All of them, yeah.
Great. And you incorporated as best you can.
We did.
Their comments that...
Very helpful, and we did.
So also my thanks to fellow regulators across this town, and you said internationally. You got comments from
Absolutely.
London and Brussels.
Right. We sent term sheets abroad and had very detailed exchange.
I support the proposed rulemaking to establish business conduct standards for swap dealers and major swap participants in their dealings with counterparties. I think this is one of the critical features of what Congress did in the statute, that there would be a promotion of the integrity of the markets in this way. Today's proposal implements those authorities that Congress asked us to do to enforce robust sales practices in the swap markets, and the rules will level the playing field and bring, I think, some needed transparency. There's even one transparency piece here. I know you keep, it's like the towel rack, but Congress did this one, which is that, and it's a form of a question, but I just want to make sure I understand it, that if you're in a bilateral relationship, because it's a customized swap or just you're an end user that happens to decide not to use a clearinghouse, you can get a daily mid-market mark-to-market on valuation. Is that correct?
That is correct.
So that's, I think, is a very positive thing to end users that the Congress did, and then we're incorporating in this rule that every day you get a chance to have that valuation directly, and it's supposed to be mid-market. I think it will strengthen the confidence in the markets. The proposed rules also prohibit fraud and certain other abusive practices. It would implement requirements for swap dealers to deal fairly with customers, providing balanced communications and disclose conflicts of interest and material incentives before entering into the swaps. And the rule also would implement the Dodd-Frank heightened duties on the dealers when they deal with certain entities, what's called special entities. And am I correct? That's largely municipalities and pension plans?
And endowments.
And endowments, thank you. So with regard to these entities, the municipalities, pension plans, and endowments, the proposed rules includes a higher standards as Congress wanted. And as Phyllis said, also it has a restriction on political contributions, certain political contributions to municipal officers by the dealers, similar to the pay-to-play restrictions that the SEC has. And you tailored these off of those restrictions, is that right?
We did. We copied.
Plagiarism was allowed for now.
Was an open
for now,
book
but
exam.
it might not be plagiarized once the public comments, and we may decide to change it. But
Always possible.
the proposed rule is intended to ensure that swaps customers get fair treatment in the execution of their transactions, and would require dealers to disclose what access they have to swap execution facilities, so that as I understand it, whether it's an end user, like the commercial end users we talked about, or financials, that the dealer would have to tell them there are these things called trading platforms and CEFs and so forth. Is that correct?
That's correct. It's a two-piece disclosure. So you disclose where the swap is trading and which markets you have access as a dealer.
And so if it's a commercial end user that has a choice whether to clear, whether to use a swap execution facility, they keep that choice, but they at least get some disclosure. Is that correct?
That is correct.
Okay. And then the rules also require the dealers prohibit the dealers from defrauding a customer by executing a transaction on terms that have, as the thing says, no reasonable relationship to the market. Now, this may be something that is very important to hear from the public. It may be something that doesn't happen often, but it at least, as I understand it, includes that as well.
It does. It's grounded in concepts of fair dealing and anti-fraud. And it derives from the principal-agent relationship in the case law and has been articulated as a reasonable relationship test.
And I also think the proposal asks a series of very important questions. And I commend Commissioner Dunn, who worked on a lot of these in terms of the dealer relationship, the counterparty relationship, and the advisor relationship, and how the two square in this bilateral world. Is that right?
That is correct. It is a complicated situation that Congress has addressed in a way through a disclosure regime. That disclosure regime actually derives from case law, beginning with the Supreme Court case in the capital gains area in the mid-'60s, which talks about when you have an advisor relationship with a client, disclosure and consent to disclosures, very material and particular disclosures, is the way to sort of put sunshine on the situation and try to mitigate the situation.
And can you, Phyllis, tell us how this proposal defines advisor?
Advisor here would have its meaning as advisor under CTA definition. But what we've done here is to particularly say that when you make a recommendation, as you would if you were a commodity trading advisor, if you make a particularized recommendation to a special entity, that would put you in the advisor box and obligate you to operate on a best interest standard of care.
So if you make, as you call it, a particularized recommendation, as opposed to a general, the markets are going up. It's not like that.
So there is a carve-out. We thought it was important not to interfere where interference was unhelpful and not necessary. We were told that when there is general market information provided to a counterparty, that should certainly not be considered advising, or when a counterparty comes to receive terms on a request basis for a transaction from a swap dealer, whatever terms that the swap dealer would provide shouldn't be considered to be advice to that counterparty.
But where they're actually structuring a deal, and so many of these dealers have structuring desks and they're working to structure something over days or maybe weeks, then that would be particular advice.
That would certainly seem to be particular advice. There is, this isn't the first time that the law has considered what constitutes making a recommendation. Our own CTA case law, the CTS decision, one, and of course on the investment advisor side on the for the SEC, as well as under FINRA case law. There's a fairly substantial body of law to provide guidance on what does constitute a recommendation in any circumstance. The circumstance that you just described seems to me to be one that would fall cleanly within.
I thank you again, and I very much look forward to the public's comments on this area. It's a very important area. Commissioner Dunn?
Thank you, Mr. Chairman, and I thank the staff for indulging me, and I thank my fellow commissioners. I know I've been the lefty here on this one, but in my mind, I think this falls within a fiduciary responsibility, and at one point that was in the statute, a proposed statute. It wasn't in the final statute, although in reading it, I think Congress gives us the authority to require that, if possible, but that may be just one of 5 opinions here. Having said all of that, I just feel that there is an inherent conflict of interest from somebody that is both an advisor and a counterpartner. And it goes against logic to say, no, there's not. But are you satisfied that what we're doing here will mitigate that conflict of interest?
Yes. I feel like what the proposed rule does and what Dodd-Frank does is acknowledge the conflict. It doesn't ignore the conflict or hide it or somehow put it under the rug. It says there is an issue here that needs to be addressed, and the way the Congress addresses it is to impose this higher duty of care, this best interest standard for the advisor in dealing with certainly the special entity. What helps in this regard, I believe, is in order to enter into a transaction with a counterparty, that special entity counterparty will have to have its own independent representative who it too will have to operate in the best interests of that special entity. So I think it is certainly possible for the special entity to be looking to its own independent representative for reliance purposes and to evaluate the recommendation that's coming from the swap dealer who would be acting both as the advisor and the counterparty. With that additional protection in that circumstance, Commissioner, I appreciate very much your concern. We have it as well, particularly as an enforcement person. I worry about things like that. I think we've gone a fair distance to mitigating, as you say. You can't eliminate the conflict. You can shed light on it and bring it to the open, and parties can make judgments.
You indicated that we're really, and the Chairman had just elaborated on that, we're looking at current body of law as we go through here, and that suggests to me that this is not static; it's dynamic, and as case law changes, this may change as well. Then my question to you as an enforcement, how do we enforce this? And how do we push the boundaries of the case law as we're going through this to come down on the side of the individuals?
I think we were given some tools we didn't have before. Well, we certainly have a lot of tools. We had no tools before with respect to this particular relationship between a swap dealer and a counterparty. It was off the bus, on the bus. What Congress did was impose very particular due diligence requirements around certification of the appropriateness of a counterparty in the first instance, and then a very robust disclosure regime. What we've done here is really incorporating the very robust language from the statute. So from an enforcement standpoint, it's sort of the tripwire to fraud. If you haven't made the disclosures, the risk is with respect to fraud. But making the disclosures or failing to make the disclosures themselves would be effective enforcement. So in that context, a robust compliance and audit program would be very helpful in ensuring that the business is going on in a way that would mitigate those conflicts that you're concerned about, and we are.
Is the division contemplating developing that type of audit group to go out and look at this?
And that's why I invited Mr. Radhakrishnan to the table today.
TCIO is contemplating. In fact, depending on how the Commission structures the agency, our staff is contemplating structuring an audit group to look at swap dealers. Of course, everything is a function of resources, but so if we get what we ask for and we get it in time, then we can do it. And notice I said get it in time as well, because getting money 2-3 years from now is not going to help us.
Is the entity that the dealers register with going to have a duty here as well?
I think it's a function of, Commissioner, as the Commission's indicate or ask the question in the registration rulemaking, the issue is always should we do it or should the NFA do it? Because I think in that rulemaking, the Commission proposed that all swap dealers and MSPs have to register with the NFA. So I don't know the answer to that. I think the answer, it could be a balance between us. And I don't want to speak for the NFA, but I'm not sure that they will have a category of members and not look at them. But as to whether we do it is, I think, is a function of resources and also, of course, what the Commission decides we should do.
I would hate to think that the public thinks we're doing a regulation out here with no follow-up, with no police on the job.
I agree with you. I suspect that, and I'm just guessing, I suspect that if we don't get, the Commission doesn't get the resources, I suspect the NFA will do it. But I hope that we get the resources just so that the Commission staff and the Commission itself gets a familiarity with how we implement these regulations.
Phyllis, you had indicated that you had talked with other agencies. How does our rules here compare with what the SEC does? Is there a difference, and why?
Let me say that the SEC, my counterpart team at the SEC got a reprieve. They were supposed to be considered yesterday, but won't be heard until next week. So what exactly?
A little like the CEF team. We're not the only ones that are human.
So I really can't tell you what will come of it. What I can say is that in the course of staff consultation and the give and take, the rules are very close. There are some things that they are taking up in different work streams. There are some things that they already have in some ways that we don't have. Execution standard is something a little bit like that. Their anti-fraud rules may or may not be included, for example, in this rulemaking, more likely, if at all, in a subsequent rulemaking. But I would say that with respect to the disclosures, we are virtually the same, and the due diligence requirements, our treatment of special entities is very, very close, or at least to be recommended, to be very close. What makes it through on both sides is, of course, up to you.
To echo the chairman, I think this is one of the key components of Dodd-Frank to ensure that we don't have a financial meltdown in the future and that people aren't taken advantage of. This is a point in time where we need to have, in my opinion, very, very strong conduct standards. We need to have standards that are fair to everyone, but they also have to be workable for the industry out there. So I really am looking forward to see the types of comments that we get on this particular conduct standards. I also note that some of the things that you took in here are based upon best practices within the industry. That connotes to me that that also is a dynamic thing that may transpire in the future. And so this is something that I think the staff and the commission ought to look at based upon what happens in case laws, what happens in industry standards, best practices out there, that we, on an ongoing basis, review this so that we can be in front, not behind.
Thank you, Commissioner Dunn. Before I turn to Commissioner Summers, let me just do on the resource question, and this might be to Dan Berkovitz or Phyllis, but just, I can't find the provision. Is it not also the case that if a swap dealer is regulated as a bank or regulated by others, it could be a registered broker-dealer, that the Federal Reserve and the bank regulators or the SEC also can examine for this, and there's the relationship as to how they can refer cases if there is an issue. Do I have that correct?
It is certainly the case. The short answer is they are frontline regulators for the same entities and can look at practices by those entities.
Great. So we're, if for some reason we don't get the resources, as Ananda said, there's still the bank regulators or somebody else who can examine for this and be, as you call it, the front line regulators. Statutorily. They might have to refer a case, but...
Correct. They could refer the case to us. We would still be the primary enforcement authority, but they could refer it to us and provide us with information, certainly.
It's another avenue. I mean, I'm thinking about this resource issue.
And what I wanted to say is keeping that in mind, we made the books and records that would be kept with respect to compliance with these rules available to appropriate prudential regulators. So there should be no artificial barrier to their access to the information.
Thank you. I'm sorry. Commissioner Summers.
Thank you, Mr. Chairman. I want to commend Phyllis and Peter and your whole team. I think that this really has turned out to be a reasonable rule and based on a lot of what Commissioner Dunn said, best practices that are in the industry. And I appreciate your tolerance for numerous comments from myself and from my office and the challenges that you had, because a lot of the rule was not very flexible. So you were working with what you had on the words on the paper. I just want to, make a comment on one of my concerns in the rule, that it started as best execution, has ended up as an execution standard, that it ensures that the swap is executed on terms that have a reasonable relationship to the best terms available. And I guess I would suggest that there seems to be, or my fear is, I guess, that there seems to be this impression that counterparties have no idea what the fair price in the market is. And if there are dealers out there that are executing swaps that have no relationship to a reasonable price in the market, that their customers are not going to be their customers for very long. So I think that this provision may be a solution to a problem that doesn't exist. And I would ask, like Commissioner Dunn did, I think that this is one provision in this rule that I would specifically ask for comment on whether it's necessary and whether or not, we are overreaching in this area. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Thank you, Mr. Chairman. I wanted to actually thank Phyllis for the proposal with regard to, you altered the best execution rule to ensure that it has reasonable execution. So I thank you for that. I see that Mark Young is here, and he brought in a group of pension funds a while back. He probably met with all of us, but I found it very helpful to listen to them. And I know that they had some concerns, and that you've subsequently had some conversations with the Department of Labor. Could you share a little bit of those conversations with us to sort of elucidate folks?
Yeah, I need to be careful. We had informal staff consultations, so the same way that if one of them had called me, nothing that I would say could bind labor or you or anything else. We wanted to take up with them get a better understanding of what the regulatory scheme was. We were quite concerned, based on what was being said to us, that there was a concern about potential inconsistency with ERISA law or some duplication in Dodd-Frank with respect to what ERISA requires. Ultimately, we had shared with Department of Labor staff the draft.
And Phil, just quickly, the pension fund said ERISA requires this whole litany of things that they're already required to do, and so therefore, maybe We didn't
Right.
need to have a litany of things ourselves. Maybe it was duplicative, perhaps.
Yeah,
So that was the issue.
That was the issue. And so, having gotten the very informal advice from the Department of Labor, we felt that it was important that we go forward in the way that that the Commission would interpret the provision to say that ERISA plans would be treated like other special entities. But there were some changes to the specific statutory criteria to take account of concerns about particular compliance that they would have. And we asked questions.
Right.
We think it requires a fuller record for us to make a judgment one way or another. And as I say, on a very informal basis, we were told that there were no concerns by staff about the approach that we were recommending to our commission.
Okay, so we're welcoming comments on this, and we know Mr. Young is a prolific writer of letters, and
That's right.
others will write to us too.
We expect to be pen pals.
All right, thank you.
Such a shout out. Commissioner Amalia.
Who's Mark Young?
I don't know. Do you want him to stand up?
No. Phyllis, my compliments, Peter, the whole team. For everybody watching, this is the rule for the little guy. And maybe they haven't paid attention and gone through, there are end user priorities, there are different provisions in the statute for the little guy, but this is something they need to look at, and it's in section 731H, business conduct standards. Now, it's a balancing act, and Commissioner Dunn's points are well taken. It has to be a workable rule, but this does provide a lot of new authority protections for the little guy, and it's an important rule. I have a couple of questions. Part 23.431 requires disclosure of material information, including the material incentives and conflicts of interest that a swap dealer and MSP may have in connection with a particular swap, including incentives from any source other than a counterparty. My question is, what kinds of incentives does the staff think ought to be disclosed under this provision? Would that include clearing incentives?
Yeah, I think as a general matter, it's understood that when swap dealers enter into transactions, they're earning a profit. So that's not particularly helpful as a disclosure. But what would be more interesting, I think, is if the swap dealer is receiving some kind of compensation from a third party unknown to the counterparty that might make a difference in the nature of the transaction that will take place. So we specifically indicated there any compensation that's received from a third party would be the type we'd be thinking of in particular.
Do you think this is the type of thing that will affect counterparty decision making?
I hope so. I hope it's meaningful, and I hope people, where that would be a meaningful disclosure to them, for whatever reason, they would act on it.
Okay. Can you elaborate on the differences between the proposed suitability requirements for swap dealers and MSPs and the NFA's know your customer duties?
That's a very close, it's a very good question, Commissioner, and it's a very close issue. Know your customer is the standard, and actually I saw Dan Roth before, so if I get it wrong, I'm sure he'll speak up. But my understanding is
The public Dan Roth is not Mark Young.
No.
He runs the NFA, which is the self-regulatory organization in the futures area.
Right, and know your customer is a concept that comes out of the SRO world and is intended to take a look at, if I understand it correctly, the qualifications of a customer to trade generally. The futures market has looked at risk disclosure and has looked at qualification of customers in a fairly generic way because of the nature of our products. Our products have been generic. They've been traded on exchange in a customized fashion. And so that Know Your Customer has worked in that environment, and I know that NFA has worked very hard to make sure that it's a robust screening or evaluation standard. But when you get into the kinds of products that are possible in the swaps world that do have differences in the risk-reward profiles, then it feels like a more transaction-based rule could have some application and may be effective in providing some additional due diligence. So what a suitability rule would do is look at recommendations to counterparties. And in connection with, on a transaction basis, if you're looking at a type of swap or a particular swap, you'd have to assess that suitability in that way. A small difference, but a difference nevertheless from the know your customer.
With regard to the execution standard that's been discussed, how will this requirement affect futures trading and contracts that trade on side-by-side on NYMEX and Globex, the floor? How might that impact a best execution or trying to achieve that?
We are viewing this to come out of a fair dealing, anti-fraud world of analysis. And so it would seem to us that we would be looking at conduct that is really over the course of a relationship. So if there was if a swap dealer was routinely sending orders for a customer to a market that had consistently worse execution standards than another, I think we would have to ask the question, we would be right to ask the question about whether that was done in a reasonable relationship to the market and therefore whether or not it was fair, reasonable, was the swap dealer acting in good faith. But the two markets that you identify, it is market neutral in the sense that wherever you can trade, you then have to evaluate the terms and then send the trades through or execute in a way that would be reasonably related to the best terms available.
The Bank of America recently paid more than $137 million in restitution to federal and state agencies for its participation in a conspiracy to rig bids in the muni bond market. Based on your knowledge of this matter, how would the proposal with regard to execution standards have protected the effective federal and state agencies?
I'm not at all qualified to comment on the particular case, but if I understand the kind of situation that was addressed there, and I think it's really important as you consider these rules today to make sure that we've done our job, that we have addressed the potential dangers in this area. There are a few things, and Congress did most of them, frankly. There is this independent representative requirement. The independent representative has to be acting itself in the best interests of the special entity. If it's true that the representative firms were not acting in the best interest, that they didn't have the sophistication, that they were not independent of the swap dealer, which is the bottom line requirement for the independent representative provision that we have. If there's a relationship between that bid rigger and the dealer, then that would, it seemed to me, to be squarely within the prohibitions that we have. We also have added, we think very appropriately, the pay-to-play restrictions, which would go a long way, I think, to cleaning up a situation that has the potential, not commenting on this case, but certainly has the potential for wrong.
One final question. Section 23.410 of the proposed rule, among other things, prohibit the employment of device, scheme, or artifice to defraud any special entity. This language tracks with the language in the CEA's new anti-manipulation provisions of Section 6C. Would a violation of this business conduct rule result in a $140,000 penalty or a $1 million penalty? And because you are a swap dealer, would you have to be fined once under the regulation and then again under the statute for the same violation just by the virtue of your registration status?
I want to answer the second one, and I'm going to give the first one to Vince. You ready, Vince?
Sure.
Okay. So, with respect to double counting, I think the Commission has given pretty good guidance in the case law that it has, and certainly federal court judges have. So we're not inclined to be receiving double counting penalties on the basis of the same exact statutory language in connection with the same conduct. So I think we're good there. And on the other, I think this was a topic of discussion and question at the earlier disruptive practices meeting, and that's why it's Vince's question.
Well, I will give no clarity because in evaluating enforcement action, we're going to evaluate all potential violations of the Act. So to the extent that we are dealing with something that is disruptive, a disruptive trading practice that is also, say, manipulative, that gets clearly into the larger calculus for $1 million per penalty, then that's going to be part of the discussion we have as a recommendation to the Commission or as part of the settlement. The question about whether fraudulent activity itself or how the disruptive trading standards are set up, that they might be different because they're talking more about fraud, I think is still a question that's a little left open for the comment period for that particular rule. But in practical experience, I go back to the first sentence, which is we would be looking at all potential violations of the Act, and so it's likely that there would be a range of sanctions that would be discussed, and so it wouldn't be one clear claim versus another.
Thanks for that clarity. I think I knew that going into the question, but...
I'm sorry.
Did you get transparency, too?
None.
I thank everyone. If there are no further questions, Mr. Staywick, if you can call the roll.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Aye. Phyllis, aye. You heard it. Even Mark Young, whoever he is, heard it.
On this question, the yeas are 5, the nays are 0.
I thank the team. Excellent work. Much more to do, but enjoy your holiday. Yeah. We have now another group coming up on the final presentation is the Commission's consideration of the issuance of an interim final rule. I would have done a break here, but I think this one's a little quicker. An interim final rule with regard to reporting of swaps, and as they come in and I just fill some time, we have already issued an interim final rule with regard to swaps that were in existence when the President signed the bill, which is called the date of enactment. And in essence, what that interim final rule said was save the information. This consideration here is a proposal on swaps entered into after the President signed the bill or the date of enactment, but prior to the effective date that some of our data rules and other things would go effective at the earliest in the late summer of next year, or maybe those effective dates will be even into months later. So with that, Susan Nathan, who is our lead of a number of our data teams, the swap data repository team you share, but a number of our data teams, Rick Schiltz, who heads our Division of Market Oversight, Dan Berkovitz, who's our General Counsel. I turn it over to the team to present this interim final rule on, in essence, saving data.
Good morning, Commissioners. There is no team to thank on this particular rulemaking, but I would like to express appreciation to Dan and his staff for their guidance in developing the rule. This morning, staff is presenting for the Commission's consideration, as the Chairman said, an interim final rule under Part 44 of the Commission's regulations. It will be Part 44.03, to establish requirements related to the reporting of transition swaps to a registered SDR or to the Commission. Transition swaps are those swaps entered into on or before the date of enactment of the Dodd-Frank Act and prior to the effective date of permanent swap data reporting rules that will shortly be promulgated by the Commission pursuant to new Section 2H5 of the Act. That provision, in turn, was added by Section 723 of Dodd-Frank and requires that the Commission adopt rules for the reporting of data related to, on the one hand, pre-enactment swaps, and on the other hand, these transition swaps. As the chairman mentioned, in September, the Commission adopted an interim final rule, Rule 44.02, addressing the reporting timetable for pre-enactment swaps. The purpose of that rule was to clarify that reporting obligations would attach to those swaps and to ensure that counterparties would preserve relevant information pending the Commission's implementation of permanent data reporting rules under Section 2H5. The interim final rule before the Commission today is similar in both substance and purpose. It directs the counterparties to transition swaps report data to a registered swap data repository or to the Commission within a specified time period or by the compliance date to be established by the permanent rules under 2H5B. The rule further advises potential counterparties to preserve data related to transition swaps until reporting can be effected, and specifically states that no counterparties will be required to create or otherwise adjust the data that they have in order to comply. It's whatever they have in the format that they have it. An interim final rulemaking is an expedited process that permits an agency to adopt, for good cause, a rule that has not been subject to the Administrative Procedure Act's requirement that the public be given notice and an opportunity to comment on a proposed rule. In an IFR, the agency publishes the rule as final, but concurrently encourages public comment. To the extent appropriate, that comment will be addressed in the permanent rulemaking. Staff believes that an interim final rule is warranted here in order to timely clarify for counterparties the reporting obligations that will be imposed under 2H5B, and thus to ensure that counterparties retain relevant data until these permanent record-keeping and reporting rules are adopted. I welcome your questions.
Do I hear a motion on the staff recommendation on this interim final rule?
So moved.
Second.
Thank you. Susan, if I might ask, I understand that this came up because in reaction to questions from market participants as to, we did an interim final rule for pre-enactment swaps, and they were asking, well, what do we do until you're, finalize it? You might want to say, why are we addressing this, and how did the question come up?
That is the primary way in which the question came up, and on the whole, once we realized that there might be some misunderstanding, it seemed prudent to come out with this interim rule just to clarify obligations and eliminate, to the extent we can, any confusion over who needs to report and what they need to do.
And am I correct in understanding the main thing we're clarifying is that what do you need to do before the effective dates, which could be, up to a year from now? Is that the main question?
That is the main thrust of this rulemaking. Stripped of its title, what this is a heads up. If you believe that you will be you are a counterparty to a transition swap, preserve whatever data you currently keep in the course of normal business practice so that it's available for reporting as necessary under the permanent rules when they're adopted.
But I do support this, but why I really like it, but I'd like to know if I'm correct on this, it's saying we're not going to be retroactive and say you have to create a different record than you currently have.
Precisely.
So until our data rules go effective, again, this could be, next fall or whatever, nobody needs to worry about going back and recreating records.
No, and the rule text itself is very clear. It's what the counterparty has on the date of enactment. If it's a slip of paper,
or even after the date of enactment,
after, yeah,
right.
Yeah.
So if it's today, if somebody enters into something today, December 9th, or after this gets into the Federal Register, it's whatever they are keeping now. They keep. And any regulatory obligations really to have a more, data fields happens later.
That's correct.
Okay. Thank you for clarifying that. I do support this. Commissioner Dunn.
Thank you, Mr. Chairman. And I was going to note in the preamble, it says the does not require any counterparties to a transaction swap transaction to create new records and permits records to be retained in their existing formats. So, are we prepared to ask for these? And if so, where would they go to? And how would we store this data, and what would we be doing with it?
Are you asking whether there is an immediate reporting obligation imposed by this rule? No, there is not. The reporting obligations will be imposed under the permanent 2H5 rules.
Thank you.
Commissioner Summers?
I don't have any questions. Thank you.
Commissioner Chilton?
I wasn't going to ask anything because I think you've done a really good job on this, Susan. But this talk of timing, I wanted to just get a little bit of a clarification. There were a couple of news articles recently. I think there was one yesterday, and I don't want to ascribe exactly who it was. I'm not sure, but I believe there was somebody at Barclays who said, "Well, it's going to take 3 years to implement this law." I don't see that happening. Congress gave us some discretion, Mr. Berkovitz. I'm going to ask you a question. And the law, and I'm paraphrasing, says that the Commission, once they promulgate a final rule, shall implement it in not less than 60 days. So what that means is that it could be more than 60 days, but that it can't be less than 60 days unless otherwise prescribed in the Act. So unless there's a different date, that minimum of 60 days before implementation. So theoretically, it is open. It is open-ended. Theoretically, at least, you could wait 3 years. That's not wise, and I don't think we'll end up there. But theoretically, you could be there. And I'm not going to get into a specific rule, but there are other places that have prescribed specific effective dates. There were just a handful. The chairman said we've done 36, but there's going to be more than 40 of these. And there's a handful of, I think, 9 of them, which had other times. And on those, there's not the sort of leeway. The Commission doesn't have the sort of leeway that we have with regard to the section I tried to paraphrase there, the 60-day. Is that correct?
Generally, yes, Commissioner. I think that's a general, a correct observation in general. The provision you referred to says, unless otherwise specified in the Act, the provisions of this Act shall be effective on the later of 360 days or 60 days after the promulgation of the final rule that is required.
Okay. I thought it was not less than 60 days.
Right. It shall be, maybe I misspoke, not less than 60 days after.
Okay. Meaning it could be more unless it's otherwise prescribed.
Correct.
Okay. Thank you very much. I appreciate it.
Thank you, Commissioner Chilton. Commissioner O'Malley? Nothing there. Mr. Staywick, do you want to call the roll?
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Thank you very much. Thank you, Susan, Rick, and Dan. At this point, I'd like to ask unanimous consent to allow staff to make technical corrections to the documents voted on today prior to sending them to the Federal Register. Do I hear any objection? Not hearing objection. So moved. Our next meeting of this commission is on December 16th, where we will review the topics that I outlined earlier, and I think we will also vote at that meeting on 2 more meetings in January on the dates. Of course, we'll be posting the various topics 7 days in advance on each of those. I also want to remind the public and the press that we have a very important roundtable tomorrow, December 10th. I think it's going to be, the venue is over at the Securities and Exchange Commission, if I'm not mistaken, but it's going to be with the Federal Reserve, the other bank regulators, the SEC, and CFTC staff hearing from important topics on capital margin. We're no doubt going to have more roundtables. Commissioner Malia And I think it is a good thing to have roundtables. I don't know which topics we'll do on one, but if there is no further commission business, I'd like to hear a motion to adjourn the meeting.
So move.
Second.
We don't have to call the roll on this, do we, Mr. Stawick? All in favor? Aye. Aye. Any opposed? No. Thank you.